Hello, everyone.
Good morning.
Hi, good morning.
Good morning.
Is everyone ready to start?
Yes.
Yeah. All right,
Yeah.
great. All right, so we'll start with the appellant. The floor is yours.
Okay, I'm the senior appellant. Should I state the amount of time that I would like allotted to me and my learned junior?
Yes, please. So if you can introduce yourself and the amount of time that will be allocated to you and the junior counsel.
Of course, okay. Good morning, everyone. My name is Ms. Najat Mustafa, and I'm the senior appellant, together with my learned friend, Ms. Anushka Menon. And my team has chosen to divide up the time as follows. I will take 15 minutes to state my arguments and save 4 minutes for rebuttal. And my learned junior will take 15 minutes to state her arguments.
All right. Please proceed. Thank you.
Okay. I will be addressing the first ground of appeal. Before presenting my submissions, I will state the essential facts of the case for the benefit of the court. Clevity is a digital trading platform where users can trade in cryptocurrency through distributed ledger technology. Clevity's digital nodes process, verify, and provide access to transactions for users. The distributed trade was a transaction that occurred in a node within the DIFC. And the users use algorithmic trading, which creates pre-programmed instructions for automatic trading. And Clevity also requires all users to maintain a $50,000 minimum cash margin, or they will be excluded. The respondent's program, Alpha, and the appellant's program, Beta, have preset instructions on buying and selling a specific cryptocurrency named YAPL. Alpha buys YAPL from Beta at a price based on its average. And additionally, Beta offers to sell YAPL at a highly inflated price if no other users offer to sell it. During an upgrade, while both parties were unaware, the platform wrongfully excluded users who had less than $200,000. So the only individuals that were able to trade were the appellant and respondent. And Beta sold 100 YPE for 250 times greater than the average price to Alpha. The respondent filed a claim in the DIFC's Digital Economy Court to void the distributed trade under unilateral mistake. The appellant issued an application challenging jurisdiction and sought immediate judgment in his favor on a point of law. He argued that there were no grounds to void the distributed trade. The court of first instance found in its favor, stating that the DIFC had jurisdiction under Article 5A1B, and citing that also held that under Article 37 1A of the DIFC contract, the court did not need, or contract law, the court did not need to examine the state of mind of the programmer when designing the program. I have 3 submissions that I would like to put before the court today. For my first submission, I would like to address the case of Kafer Alimentos S.A. de CV and AMS Drilling Mexico S.A. de CV and others, reported in the 3rd volume of the 2019 All England Law Reports on page 979. Would my lady wish to hear the facts of the case?
Yes, please.
Okay. For the benefit of my lady, I will state the necessary facts of this case. In this case, the claimant entered into a contract that tasked them with refurbishing a jackup rig. The second defendant had established a contract, but stated invoices should be sent to the first defendant. Furthermore, the contract had included a clause that the High Court in London had jurisdiction over the resolution of any disputes arising in connection with the supply of goods. The claimant brought legal action against the first, second, third, and fourth defendants. They attempted to argue that the English courts had jurisdiction over the third and fourth defendants due to the first and second acting as their agents. The High Court dismissed their claim and they appealed. However, the Court of Appeal chose to dismiss the claimant's appeal. The Court of Appeal's decision as to what must be considered in assessing jurisdiction is mentioned in the legal article titled English Court of Appeal confirms three-part test for jurisdiction disputes, written by James Wagner. The article states that in order to obtain permission from the English courts to serve proceedings, a claimant must show the court that, number one, there is a serious issue to be tried and that the claim has a real prospect of success. Number two, there is a good arguable case that the claim falls within a prescribed jurisdictional gateway, so the English law governs the contract in dispute. And number three, England is the most appropriate forum to hear the claim.
Sorry,
Therefore,
Counsel, I'm going to... Counsel, sorry. Where is this mentioned?
This is mentioned in the article titled English Court of Appeal confirms three-part test for jurisdiction disputes.
Okay.
Yes. Therefore, it is my respectful submission that the assessment of jurisdiction established in this case should be adopted by the DIFC Court of Appeal. The DIFC utilizes relevant case law from prominent common law courts. When applying the assessment to the current case, my learned friends may be able to argue that the first component may be fulfilled. However, it is evident that the DIFC does not fulfill the second component of the test. As previously stated, the second component examines whether the DIFC is a, quote, prescribed jurisdictional gateway, end quote. In other words, whether DIFC law governs contracts in disputes. While my learned friends may attempt to argue that DIFC law does hold authority over the disputed contract, the nature of private blockchain demonstrates that they do not. This brings me to my second submission. For my second submission, I would like to court the information research journal titled under paragraph 2. That, quote, administrators may maintain an access control layer to allow certain actions to be performed only by certain identifiable participants, end quote. It is mentioned within the case facts that Clevity does not allow participants to participate. Can everyone hear me?
Counsel, we can hear you, but you're cutting off. It's
sorry,
fine
just
now.
1 minute.
I'll let you know if it happens again.
Yeah. Is it clear now or is it still cutting off?
No, it's fine now.
Okay. It's mentioned within the case facts that Clevity does not allow participants to participate in trading if they fail to maintain a minimum $50,000 cash margin in their accounts. Therefore, it can be categorized as private blockchain. This is critical as a key characteristic of private blockchain is that it is centralized. This is explained in the research article titled A Detailed Review on Private Blockchain and Its Applications, written by Akash Khatri, under the subsection titled Types of Blockchain. The subsection explains that private blockchain is, quote, a network that is centralized due to the fact that only a single organization controls it fully, end quote. This diminishes the argument that the DIFC may have jurisdiction based on the node's location, because authority is not distributed across nodes in private blockchain, as this is a characteristic of public blockchain. Instead, control firmly resides with Clevity. Having full control indicates that Clevity also possesses authority over consensus determination of the transactions. Consensus determination involves determining the validity of every transaction that occurs within the blockchain, as explained in the article's subsection title, Consensus Determination. The subsection explains that, quote, a single firm fully controls the private blockchain and the final consensus is determined by the firm, end quote. The final consensus regarding the contract established between the defendant and claimant was determined by Clevity and not the nodes. Therefore, it is my respectful submission that the establishment of DIFC jurisdiction under Article 5A 1B of Judicial Authority Law is false. Article 5A 1B states that DIFC has jurisdiction over contracts that are, quote, finalized in the DIFC, end quote. However, as explained above, the contract was concluded and finalized by Clevity not the node in DIFC. Therefore, it is my respectful submission that the DIFC fails to fulfill the second requirement of the three-part test due to not governing the disputed contract. The DIFC also fails to fulfill the third component of the assessment from the Alimentos case due to not being the most appropriate forum to hear the case. The DIFC is not the most appropriate forum due to Clevity operating on a distributed yet centralized ledger. This brings me to my third submission. For my third submission, I would like to draw the court's attention to the information contained in the book titled Oracle Blockchain Services Quick Start Guide, written by Yerapati, Prakash, and Acharya under Chapter 1, Subsection 3. The subsection states...
Sorry, Counsel, when was this book published? What year?
This book was published, if I'm correct, this book was published in 2020.
Okay.
If I'm not wrong, yes. Excuse me, actually I meant to say 2019.
Okay.
The subsection states that distributed yet centralized systems are, quote, distributed from the location's perspective, yet the system is controlled by a central authority, end quote. Distributed yet centralized ledgers mirror the characteristics of private blockchain. Control firmly resides with Clevity, and the location of the nodes is once again proven to not be significant in terms of establishing jurisdiction. If control resides with Clevity, then they alone may choose what jurisdiction or protocols may apply should disputes arise. This is explained in the journal article titled, Where is Blockchain? Jurisdictional Issues That May Affect Distributed Ledgers, produced by Burr and Foreman LLP, under paragraph 4. The paragraph explains that distributed ledgers may, quote, establish a choice of law provision that applies to all of the nodes on the ledger's network, end quote. There is no mention of the DIFC being chosen as the law provision to apply to all nodes within Clevity, or all Clevity's nodes, so they cannot presume that they possess jurisdictional authority on the basis of location. Therefore, it is my respectful submission that because the DIFC is not the chosen law provision, it fails to fulfill the third factor of the assessment. In conclusion, it is my respectful submission that the judgment found by the Court of First Instance should be overturned. As explained above, when the assessment for jurisdiction is applied to the DIFC courts, it is evident that they fail to fulfill the requirements explained in Part 2 and 3 of the Alimentos assessment. The DIFC is not a jurisdictional gateway due to Clevity being private blockchain, and is not the most appropriate forum to hear the case due to Clevity operating on a centralized yet distributed ledger. Furthermore, if the DIFC lacks jurisdiction, then the section of the judgment made by the Court of First Instance that held the contract to be void for mistake under Article 37, Subsection 1, Section 1, Subsection A would be invalid. This concludes my submissions. Thank you.
Thank you, Counsel. Appellant Junior Counsel.
Yes, hi.
Are you ready to proceed?
Yes.
Please go ahead. Thank you.
Thank you. All right. Good morning, everyone. As introduced by my learned friend, Ms. Najat Mustafa, my name is Ms. Anushka Menon, Junior Counsel for the appellant, Mr. Payne. I will be addressing the second ground of appeal, and for the benefit of the court, I shall restate the ground. The second ground concerns the question, did the first instance court err in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, Section 1, Subsection A of the DIFC contract law that Ms. Razi show a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. As my learned senior has already presented the facts of the case before us, I will begin my submissions in respect to the second ground of appeal. My first submission is that the court erred in the application of law regarding Article 37, Section 1, subsection A of the IFC contract law, and that there was no unilateral mistake made due to which the disputed trade occurred. The second ground states that a reasonable trader should have had knowledge of the mistake. To support the initial judgment, the first instance court had applied the reasoning of Lord Mance, who had sat as an international justice of the Singapore Court of Appeal in Coin Private Limited and B2C2 Limited 2020 Singaporean Court of Appeal. Coin was the first case in which the defense of unilateral mistake was presented in relation to algorithmic trading and the formation of contracts through the same. In Coin, while assessing the criteria for knowledge of the circumstances regarding the mistake, Lord Mance had argued that the court did not need to examine the state of the mind of the programmer when they designed the program to qualify the contract for mistake. This, however, had been the dissenting opinion in Coin and was criticized by the majority for being quote-unquote wholly artificial. However, Chief Justice Menon, in agreement with the initial judgment, refused to consider the matter by reference, quote, to what the position would have been and what the contracting parties were likely to have known, intended, and agreed had they had face-to-face negotiations at a hypothetical meeting on the quote-unquote floor of exchange to enter into the trading contracts at the time these were entered into, because this was simply not how they had agreed to form their contracts, end quote. When applied to this case, it is not sufficient for Ms. Razi to only show that a reasonable trader with sufficient knowledge would have agreed that the disputed trade was made based on an error. The trade had been made by deterministic algorithms, which are designed to simply trade as per their program parameters instead of forming new responses based on the market. It was the opinion of Chief Justice Menon in the Coin case that in cases which involve contracts or trades made by deterministic algorithms, to assess knowledge of a mistake, the state of mind of the programmer at the time of programming the algorithm must be taken into account. When Mr. Payne had programmed Beta, the program in question, he had not made the same mistake as Razi or caused her mistake, and he did not and could not have known about her mistake. In Coin, the judge held that in relation to unilateral mistake, the state of mind of the programmer is relevant. The state of the mind of the programmer of the relevant program must be regarded, and it would be wholly artificial to approach the matter from a hypothetical floor of exchange situation. As the involved parties had chosen to use deterministic algorithms, they had created consensus ad idem and agreed that they would not be seeing the terms of the contract when it was made. Additionally, when Mr. Payne had created Beta, he had not programmed it with malicious intent to exploit a potential mistake in the software by another party. As the program had been created prior to the disputed trade, there was no way for Mr. Payne to have known about the relevant mistake. This is supported by Professor Goh, who was the amicus curiae in Coin. He had cited Nick Yeo and Joseph Farmer from Mapping the Landscape Cryptocurrency Disputes under English Law, Part 2 in 2019. The argument mentioned here is that traders must quote, necessarily have arisen. The argument mentioned is that the trader's mistake must, quote, necessarily have arisen or at least have been continuing at the point of the original trades, end quote. However, both the parties had used deterministic preset programming and by practical necessity had last inputted programming into their algorithms prior to the disputed trade. Following this reasoning, it would not be possible for Mr. Payne to have knowledge of the circumstances of the disputed trade or for him to have changed the programming prior to the mistake. I submit that the court examined Mr. Payne's state of mind at the time that he had programmed the algorithms due to the reasons stated above. My second submission for this ground is that Mr. Payne's state of mind at the time when he had programmed the algorithm was not to exploit any mistakes such as the one that led to the disputed trade. Article 37, subsection 1, subsection 1A of the DIFC contract law states that a party may only void a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and that the other party had made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. When Mr. Bain had created beta, as stated previously, he had not programmed it with the intention of exploiting a potential mistake in the software or by another party. The insertion of the inflated price programming was merely done to ensure that the program would remain functional in the unlikely scenario that there were no other users offering to sell Yapo and would still be able to make a profit. This reasoning was also accepted in Coin, where the judge had concluded that while the respondent's programming was opportunistic in that he ensured he would make a profit in an unlikely situation, quote, it was in no respects sinister, unquote. And this reasoning should similarly be applied in this case. In relation to subsection 1, subsection A of Article 37, when Mr. Payne had programmed beta, he had not made the same mistake as Ms. Razi or caused her mistake and did not and could not have known about her mistake. Mr. Payne, like Mr. Bonin in Coin, did not have actual knowledge of the mistake at the time it was made, nor could he have predicted the mistake which led to the disputed trade at the time of programming. Therefore, neither did Mr. Payne maliciously program beta to exploit a mistake in the software by another party. He had also not made the same mistake as Ms. Razi, nor did he have knowledge about the mistake. Therefore, I submit that this contract is not viable to be voided under Article 37, subsection 1, subsection 1A of the IFC contract law. The third submission I will be presenting to the court is that there is no unilateral mistake under common law or in equity, as the disputed trade does not satisfy the requirements for either. The requirements for unilateral mistake at common law and in equity were set out in Chui King Kyung and others and Digiland Mall Private Limited in 2005. And it states that one party, quote, must have transacted while operating under a mistake as to a fundamental term of the contract, unquote. Furthermore, for unilateral mistake at contract law, the non-mistaken party must have had actual knowledge of the mistaken party's mistake. And if this is established, the contract will be rendered void. But for unilateral mistake in equity, the non-mistaken party must have had at least constructive knowledge of the mistaken party's mistake and must have engaged in some unconscionable conduct in relation to that mistake. And if this is established, the contract will be voidable. Unilateral mistake under common law can only void a contract or trade if one of the involved parties is mistaken about the terms presented by the other party and the other party is aware of this. In this case, by electing to use such algorithms to carry out their trades as opposed to conducting the trades themselves, the parties had agreed to trade in a way in which they would not know about the trade, nor the terms under which it was carried out. Therefore, it would not have been possible for Mr. Payne to have had actual knowledge of the mistake. As such, the disputed trade cannot be voided for unilateral mistake under common law. In relation to unilateral mistake under equity, he also did not have constructive knowledge of the mistake, as it was established that both parties were asleep at the time that the disputed trade took place. Additionally, Mr. Payne had not engaged in unconscionable conduct in relation to Ms. Razi's mistake, as he would have had to prophetically determine the exact circumstances which led to the disputed trade and then program beta accordingly. As stated in Coin, quote, programmers are not expected to be prophets, unquote. Therefore, the disputed trade cannot be voided for unilateral mistake under inequity as it fails to satisfy the requirements. In summation, the disputed trade cannot be voided for unilateral mistake under common law or inequity as it fails to satisfy the requirement for either. For my final submission, I submit that the court applied the Article 37, Section 2, subsection B of DIFC contract law for the disputed trade. Article 37, Section 2, subsection B states that a party cannot avoid the contract if, quote, the mistake relates to a matter in regard to which the risk of mistake was assumed or, quote, having regard to the circumstances should be borne by the mistaken party, unquote. As both parties had agreed to use deterministic algorithms to carry out their trades, they had assumed the risk of not pre-evaluating the terms of the trade. By agreeing to carry out their trades via deterministic algorithms, both Ms. Razi and Mr. Payne agreed to the formation of contracts without reviewing the terms prior to trading. Therefore, the risk of mistake was assumed and the consensus addendum was created between the two parties involved. Therefore, if this proposed article is applied, then Ms. Razi must instead bear the mistake and may not avoid the disputed trade. For the reasons stated above, the first instance court erred in dismissing Mr. Payne's applications and should allow Mr. Payne's appeal. By applying Chief Justice Menon's reasoning in Coin, the court should find that Mr. Payne did not program Beta maliciously to exploit any mistakes in the program or by other users, and did not have knowledge of Ms. Razi's mistake, nor did he cause it. As the disputed trade fails to satisfy the requirements for unilateral mistake at common law or in equity, it cannot be voided. And lastly, the court should apply Article 37, Section 2, subsection B to the disputed trade. This concludes my submission for the appellants.
Thank you, counsel.
Thank you.
Hello, am I audible?
Senior counsel for the respondent,
Yes.
you may proceed.
May it please the court, your lordships. My name is Faiza Farhana and I appear in this case with my learned junior Shweta Saboji on behalf of the respondents. Your lordships will be addressing two grounds of appeal. Firstly, that the court of first instance did not err in concluding that it had jurisdiction.
Counsel?
Yes, sir.
Sorry,
Yes,
can you please state the time allocated for you
Yes.
and the junior counsel? Thank you.
Yes, your ladyship. Your ladyship, as a senior respondent, I will be taking 18 minutes, reserving 4.5 minutes for the sir rebuttal, and the same division will be followed by my learned junior.
Thank you.
Okay. Your ladyship, so the first ground of appeal that we are contesting is that the court of first instance did not err in concluding that it had jurisdiction under Article 5A1B of the Judicial Authority Law, number 12 of 2004. And my learned junior will be addressing the second ground of appeal, which is the court of first instance did not err in concluding that for the purpose of satisfying Article 37(1)(a) of the DIFC contract law, it is sufficient that the respondents display a reasonable trader with the knowledge of the circumstances would have concluded that the disputed trade was result of an error. Your lordships, in regards to my first ground of appeal, I have two submissions to make. Firstly, that the node in the geographical territory of DIFC allowed for Ms. Rani to perform or conclude the contract. Your lordships, the gateways in Article 5A(1)(b) of the Judicial Authority Law number 12 of 2004, if you may please refer to page number 31 of the code bundle, clearly sets out the exclusive gateways on which DIFC's jurisdiction is based. Quite specifically, it doesn't relate to the location of the parties, nor the location of the respondent or the appellant, but merely the subject matter of the jurisdiction, your lordships. Lordship, in specific to Article 5A(1)(b) of the Judicial Authority Law, it only has a very low threshold. That is, any transaction, that is, any commercial or civil dispute that arises out of a contract that is even partially or wholly performed, concluded, or executed in DIFC will be met by DIFC's jurisdiction, your lordship. In that regard, the location of the parties are immaterial to this case. Your ladyship, I would also like to refer you to the case of Shihab Khalil versus Showa Capital, which was held in 2009 by the Court of First Instance 017, which can be found on page number 53 of the code bundle, quite specifically paragraph 18. Your lordship, the court in this case has interpreted the meaning of the word arose out of and related to, as well as the meaning of the word conclude. The word arose out of would mean two things. Firstly, the claimants to the case must be a party to the transaction or the contract. Your lordship, it is quite evident that Ms. Razrani had accepted the offer from Mr. Payne and is a party to the contract. Secondly, there must be an essential cause of action. Ms. Razi is asking for avoidance of the contract on the grounds of relevant mistake, and thus there is an essential cause of action. Your lordship, secondly, the word conclude would mean partly entered into or even wholly entered into. Your lordship, now in the context of the facts of the case, Mr. Payne had made an offer to Ms. Razi through his algorithm program by the name of Beta. Ms. Razi had accepted this offer through the algorithm Alpha. Lordships, in absence of the note in DIFC, Ms. Razi could not have entered into this very contract, your lordship, that is even partially or even wholly. That is because the nature of the notes in a distributed ledger technology is that they act as mediums of communication. Apart from being endpoints of communications between the network, they also allow for the users to take part on the platform. So apart from entering or trading on the platform, the only way Ms. Razi could have even entered into this very contract, or in the words of Shihab Khalil, conclude partially, would be through this very node in DIFC, your lordship. Moreover, the nodes in a distributed ledger technology, they execute smart contracts. When predetermined conditions are met, it triggers these nodes to act upon those pre-programmed instructions. In that regard, in the context of the present case, when the predetermined condition of the best possible price and the average price have been met, it triggered the node to act upon that very specific contract. And it executed this contract. Your Lordships, I would also like to contest with what the appellants have stated, that this distributed ledger is a public private ledger. Your Lordship, these are mere assertions that are not clothed by facts of the case. Firstly, it's an immutable manner, as the paragraph 1 clearly suggests. There is a simultaneous access, validation, and record updating in an immutable manner. It is the immutability aspect of this very distributed ledger that gives it a public blockchain nature as opposed to private blockchain nature. Your Lordships, for this, I would like to rely on the FinTech notes that was published by the International Monetary Fund by Bainsby in 2020-22. It is cited on page number 81 of the code bundle, Your Lordships. Furthermore,
what weight does this carry before this court as a reference?
Your Lordships, it's merely persuasive. It's an academic text. The academic text has been followed by several courts for reaching at the conclusions. So I hope the fact that it's by an IMF would be persuasive enough. Your Lordship, if I may proceed with my submissions. Your Lordship.
Yes, thank you, counsel.
Your Lordships, in that aspect, this node in DIFC had executed the transaction and had displayed or broadcasted this specific contract to all the other nodes in the network. Upon consensus, it is then synchronized to all the ledgers. That is why it is called as a decentralized ledger, Your Lordship. In that regard, this node in DIFC had played an essential role in facilitating this contract. Your Lordships, in regards, I would like to refer you to the case of Khorafi versus Bank Sarasin, 2011 DIFC, which was held in the Court of Appeal 003, specifically, which can be found on page 42 of the code bundle, paragraph 59. In this case, the matter was between the Kuwaiti plaintiffs as well as the Bank Switzerland, Bank Sarasin Switzerland. However, the Dubai branch of Sarasin was implicated in this matter because it was performing an essential role in conclusion or negotiation of a contract, Your Lordships. And in that regard, this node in DIFC, apart from only having an essential role, it partly performed as well as concluded this contract between the parties, Your Lordship. Moreover, the place of performance of transactions on a node can be attributed to the nodes. This was addressed by the US case in the case of Ray Tezo's civil securities litigation, which can be found on page number 50 by the Ninth Circuit Court of Appeal in 2018, Your Lordship. In arriving at this conclusion, Judge Seberg has clearly stated the nodes were determinative because the transactions occurred in the US. In this matter, the case was between the US as well as the a UK-based blockchain platform. Though the legal side was specifically mentioned to be that of England, the US had jurisdiction merely because, number one, much of the validating nodes were clustered in the US. Secondly, it was hosted on a server in the US. And thirdly, the plaintiffs had purchased the coins from the Tezos Foundation, that is the respondent company from the US. In that regard, Your Lordships, we can draw parallel to the present case at hand. The threshold of 5A1B being very low, the fact that the node in DIFC participated in the negotiation as an essential step and in furtherance of an activity would be enough to suffice that this first requirement is met. Secondly, it's an undisputed fact that these nodes are hosted on a server which is operated by Clevity in DIFC, Your Lordships. In that regard, even servers are determinative, determinative of the jurisdiction, Your Lordship. Lordships, just a minute.
That's fine.
Apologies for the intervention. Your Lordships, I would also like to cite another case in reference to this. That is the case of Alibaba Group Holding Limited versus Alibaba Coin Foundation, case number 18 CV 2897, which was held by the Southern District of New York in October 2017. In this case also, the justice had clearly stated that the servers on which these nodes are hosted are fundamental to meeting the jurisdictional matter. Your Lordships, I would like to distinguish from what the appellants have stated. Firstly, when there is an exclusive jurisdiction by the DIFC code, there is no requirement to have a jurisdictional clause. It is the fault on the side of the appellants that they have not mentioned an opt-out clause. In presence of an exclusive jurisdiction and absence of an opt-out agreement, it would be the exclusive jurisdiction of DIFC that operates. In reference to this, Your Lordships, I would like to cite you the case of Alliance Risk Transfer AG Dubai versus Alain Ahlia Insurance Company, which can be found in page number 33, paragraph 39 to 40, Lordship. In this case, similarly, it was held that the contract was signed in DIFC, therefore the gateway 5A1B was met. Secondly, they did not have an opt-out clause in line with Article 5A3 of the Judicial Authority Law number 12 of 2004, which is why DIFC had jurisdiction over the matter. I would also like to distinguish the jurisdictional gateways of UK, which our learned appellants have mentioned, from the current gateways, Your Lordship. Your Lordship, the way for determining jurisdictions in UK is quite different. In fact, the Article 5A1B is very expansive. It can serve defendants even out of the territorial matter. It was held in the case of Corinth Pipeworks SA versus Barclays Bank, which was held in the DIFC Court of Appeal, that the service on the outside of jurisdiction can be effected anywhere in the world, provided that they can be brought under Article 5A1 of the Judicial Authority Law number 12 of 2004, Your Lordship, and paragraph 18 of that very case. Therefore, the jurisdictional gateways being different, we cannot apply the test which the appellants have suggested, Your Lordship. That is because the jurisdictional gateway under Article 5A1B is very vast and expansive, and it's irrelevant to determining jurisdiction, whether the location of the parties or the public or the private blockchain aspect of this, Your Lordship. Your Lordships, also the appellants have contested the jurisdiction or the forum, however, they have not performed an appropriate forum. Your Lordship, my second submission is in regards to the application of forum non-convenience. Since the appellants have not contested this, I will not go further into details. However, Your Lordship, this is a discretionary power of a court to transfer the matter. Considering the fact that DIFC has exclusive jurisdiction and no opt-out clause, there is no more an appropriate forum than DIFC. The appellants have quite clearly failed to recognize an appropriate forum which must litigate the matter. Your Lordships, the DIFC court, apart from having the exclusive jurisdiction, it also has a specialized division that can pertain to the matters in this case. Your Lordships, if you may please move to page number 26 of the court bundle. It states out the DEC rules. So DEC rules are digital economy codes that can pertain matters that arise exclusively out of distributed ledger technology as well as cryptocurrency, which this code is more than capable of litigating. In that aspect, Your Lordship, the case must stay in DIFC code as there exists no appropriate forum than DIFC codes, Your Lordships. Your Lordships, for this, I would like to rely on the case of Protivity Member Firm Ltd versus Almohal 2016 DIFC Code of Appeal 003, which can be found on page number 48 of the code bundle, specifically paragraph 22. It is on the defendants, or in this case, the appellants, to prove that there exists another forum to litigate the matter if they contest a jurisdiction. Secondly, they should not only prove there exists another forum, but also it is more appropriate, which they had failed to do so. Therefore, taking into the consideration that DIFC courts are international courts that can litigate in English as well as apply international common law principles, the DIFC court must litigate the present matter at hand, Your Lordships. In that regard, that concludes my first round of appeal. Your Lordships, it was a pleasure arguing in this court. I will now refer the court to my learned friend for their respondents.
Thank you, counsel. Junior counsel for the respondent.
Yes, Your Lordships. May it please Your Lordships, as already been... Yes, Your Lordship.
Yes, you may proceed. Thank you.
May it please the Honorable Court, as already been indicated, my name is Shweta Sabuji and I appear for the respondents in the second round of appeal. In relation to the second round of appeal, there are three submissions to be made. The first submission being the act done in good faith. It is humbly submitted before the Honorable Court that the contract was not in accordance to good faith. Good faith basically means the observance of reasonable commercial standards of fair dealing. If the concept of good faith is not being applied in the contract, it will lead to an imbalance and hence would be unfair. May I refer your lordships to the case of CPC Group Limited versus Qatari Dai Real Estate Investment Company, which can be cited on page number 14 of the bundle. And this was held in England and Wales High Court 2010. It was stated that observing reasonable commercial standards of fair dealing and acting consistently with the justified expectations and being faithful to the agreed common purpose is very necessary so that the contract will become enforceable in nature. Now, I may refer to your lordships to the case of Yam Singh PT Limited versus International Trade Corporation Limited, which can be cited in page number 69 of the bundle. And again, this was held in England and Wales High Court 2013. The council like to give stress on the term that good faith is implied in nature. Hence, it is an implied duty of the parties to act in good faith. Furthermore, I may refer your lordships to Article 1.7 of Unified Principles of International Commercial Contract 2004, which can be found on page number 21 of the bundle. It states that the concept of good faith and fair dealings is the fundamental and the core to any contracts. It also conveys that the parties has a duty to act in accordance with good faith and must not exclude or limit it. Hence, one can understand the importance of good faith in contracts. In addition, I may refer your lordships to Article 56 of DIFC Contract Law number 4 of 2006, which states that the concept of good faith, fair dealings, and reasonableness is implied in obligation. Hence, good faith is the faithfulness to scope, purpose, and terms of parties to contract. To ensure that both the parties get benefit out of the anticipated benefits of the contract, both the parties have a duty to act in good faith to the contract. Moreover, there are several business norms that leads to fair dealing. One such standard agreement where every contract has is that it won't have an inflation of price. The council would like to elaborate this point by giving two scenarios. The first scenario being when the seller sells the goods to the buyer at a highly inflated price and the buyer agrees to the same and proceeds to buy. This is enforceable in nature. On the other hand, when the seller sells the goods to the buyer at a highly inflated price, this scenario can be applied to the present case as taking in consideration the implied concepts of good faith and reasonableness. Hence, a reasonable person would not enter into such a contract. As stated before, observing reasonable commercial standards of fair dealing and being faithful to the agreed common purpose is very necessary so that the contract will become enforceable in nature. May I refer your lordship to the case of... Yes, lordship?
Please proceed.
Indeed. May I refer your lordship to the case of Braganza versus BP Shipping, which can be found on page number 56 of the bundle, and this was held in United Kingdom Supreme Court in 2015. It was stated that the duty must be rational and in good faith. Hence, in the present case, the act was not in rational as well as in good faith, as the price was inflated 250 times above the price. I would again like your lordships to refer to the case of Braganza versus BP Shipping, which is again to be found on page number 56 of the bundle. And the Braganza duty requires the decision to exercise in discretion, honestly, and in good faith. And the concept of a good faith, and it must be in absence of arbitrariness, capriciousness, perversity, and irrationality. A so-called Braganza duty is implied obligation to act rationally and exercising contractual discretion. The implied concept of good faith and fair dealings is also being used in all the courts of the United States and require every party to act in a reasonable manner so that the contract becomes valid and enforceable in nature. In accordance with the case law by the Chief Justice Bathurst in the case law of Cordon Investment Limited versus Leicester Properties Limited, which stated 3 points in regards to good faith. The first point being an obligation of the parties to cooperate and achieve the contractual obligation. The second point, the compliance of honest standards of conduct. And the third point, the compliance of honest standard of conduct of a reasonable person. Hence, the inherent and imbalance of power can lead to an opportunistic practice. And hence, there must be a good faith in all the contracts to promote the integrity and ethics of the contract. Moreover, in regards to Australian common law, the development of good faith began in recognition to the duty to cooperate. Duty to cooperate basically means to act in good faith. Hence, as good faith is given a lot of importance in across all the jurisdictions. There must be, in this case, there is no mention about good faith as the cryptocurrency was sold at a very inflated price, that is 250 times more than the actual price. Hence, in this case, there's no good faith. Now, the council would like to move on to the second ground, which deals with mistake. May I refer your lordships to Article 37 of DIFC Contract Law number 6 of 2004, which can be found on page number 29 of the bundle. In order to prove mistake under this article, one has to prove the non-existence of good faith and non-existence of reasonableness. The council has already talked about the non-existence of good faith in my before submission, and the council would like to talk about the non-existence of reasonableness in my further submission. Moreover, the mistakes had occurred in the instant case as one party is laboring under the misunderstanding as how the code
Counsel?
operates. Yes, my lordship.
Sorry to interrupt. Can you kindly quote this article?
Your Lordship, I'm referring to Article 37 of the IOC Contract Law number 6 of 2004. And to prove that there must be we need to prove there must be an non-existence of good faith as well as non-existence of reasonableness.
Thank you.
Yeah, thank you, Your Lordship. May I refer Your Lordship to the case of Hartog versus Colin and Shields, which can be found on page number 62 of the bundle. And this is mentioned in all England law reports, and this was held in 1939. And in that case law, they referred to a principle called snapper principle, which basically means when it is obvious that one party is laboring under a mistake, and the other party cannot snap up and enforce the contract. This is mainly because it is unconscionable to do so. Hence, there must be a secure, sufficient protection of consumers against unfair practices which arose in those contracts. Hence, Ms. Rani, being a reasonably sound trader, was aware of the fact that she was never go forward with such a contract as the price was 250 times more than the actual price. Moreover, hence, the council would also talk about the third argument. The council would like to move on to the third submission, which talks about objective approach. The objective theory of contracts basically mean it's an agreement between parties which is legally binding on the opinion of a reasonable person at that point of time. And hence, the objective theory is a sound approach for determining the assent because it reflects the pragmatic reality of the law and it does not depend upon the externalities. And hence, it depends upon the reasonable expectations of a reasonable person. And this is considered to be a hallmark principle for freedom of contracts and personal autonomy. May I refer your lordship to the case of Smith versus Hughes, which can be found to page number 65 of the bundle, and this is mentioned in Law Reports of the Queen's Bench Division 1871, which Spencer stated that the objective theory are the words to be interpreted as they were reasonably understood by a man. And Spencer has also taken this dictum from Blackburn J, and this was to be cited in page number 76 of the bundle. The objective theory also characterized as a tool of the courts to evaluate the formation of the contract, and the objective theory is the initial analysis of a contract to which we can understand the enforceability and validity of a contract. Moreover, a reasonable person would only go for a reasonable price. A reasonable person is a hypothetical individual who approaches any situation with the appropriate amount of caution. On the other hand, a reasonable price is one where a person is willing to pay. Now, I may refer your lordship to the case of CoinPT versus B2C2, which was held in International Justice of Singapore Court in appeal. And the council would like to refer the opinion of Lord Mans. This is to be cited in page number 56 of the bundle, and to be more specific, paragraph 28. In accordance to this opinion of Lord Mans, and in referring to the facts of this case, Mr. Payne's state of knowledge for the purpose of proving Article 37, Clause 1, Subclause A of the DIFC Contract Law number 6 of 2004, the court did not need to examine the state of mind of the programmer while designing the program, as it is sufficient that a reasonable trader at that point of time would not enter into such a contract. Lord Mans also commented that what was prescribed as unreasonable in the sense of conduct or a decision is to which no reasonable person having the relevant discretion could have subscribed. If we remove the AI algorithm factor, we are left with two parties, Payne and Razi, where one party is selling the asset at a highly inflated price, and according to a reasonable person, would not enter into such a contract because it is highly inflated. Moreover, Rajrani is considered to be a person with ordinary degree of reason, prudence, care, foresight, and intelligence, whose conduct, conclusion, expectations in relation to the particular circumstance or fact used as an objective standard which measure and determine something where a reasonable person would not enter into such a contract. Reasonableness is also used in other common law jurisdictions. For example, the Australian contract law, which tackle contractual behavior and avoid walking blindly into danger. And hence, as this case completely satisfies all the elements of the Article 37, Clause 1, Subclause A of the DIFC Contract Law number 6 of 2004, we can conclude that the disputed trade was a fact, a result of an error. The principles of justice, equity, and good conscience must be applied for the deliberation of this case. Moreover, the council would like to contest what the appellant said, where the appellants has talked about the dissenting opinion of the Lord Mans. This dissenting opinion of Lord Mans can be applicable to the present case, as the facts of the case is more relevant according to what the opinion of Lord Mans. Moreover, the one can predict the mistake as the concept of reasonableness, good faith is implied in a contract. The concept of good faith and reasonableness should not be expressed as it is already implied and the fundamental to any contracts. It is the core of any contracts. Moreover, therefore, Your Lordships, to conclude, I submit that the judges did not err in concluding that the DIC contract law has jurisdiction over the claim under Article 5A1B of the Judicial Authority Law because Clevity operated distributed ledger with a node in DIFC. Moreover, the judge did not err in proving Article 37, Clause 1, Subclause A of the DIFC Contract Law number 6 of 2004 because a reasonable trader with the knowledge of the circumstance would not have concluded the contract. Your Lordship, it was a pleasure arguing in this court. May the counsel be of further assistance to this court.
Thank you, counsel.
Much obliged, Your Lordship.
We will now proceed to rebuttals. Senior counsel for the appellant, you may proceed. Thank you.
Thank you. The DIFC has attempted to assert jurisdiction over the disputed trade based on the node's location, as they held that they have jurisdiction due to the contract being, quote, finalized in the DIFC, end quote, under Article 5A1B of the Judicial Authority Law. However, as previously stated, node location is completely irrelevant due to Clevity being a private blockchain. It is fully insufficient to claim that stating Clevity being private blockchain is based on assumption. Clevity cannot be public blockchain because public blockchain lacks the characteristic of being able to exclude specific users. This is a characteristic solely possessed by private blockchain. Therefore, Furthermore, as I explained in my submission, authority is not distributed across nodes in private blockchain because control firmly resides with the single firm, that being Clevity. This also means that Clevity possesses authority over consensus determination of transactions because Clevity operates on a distributed yet centralized ledger. The DIFC node had absolutely no role in finalizing and determining the validity of the transaction, as this was solely done by Clevity. Therefore, the argument under Article 5A1B is completely diminished. Furthermore, it also proves that DIFC is not the most appropriate forum and is not a jurisdictional gateway, as explained in the information that I stated in my submissions. Thank you.
Thank you, counsel.
Your Lordships,
Junior,
I proceed with the.
yes, please proceed. Thank you.
Your Lordships, may I please proceed with the third rebuttal for the senior appellant?
Yes, please proceed.
Yes. Your Lordships, there is nothing in the facts of the case that suggests that this is actually a private blockchain. As I stated earlier, the paragraph 1 clearly states the distributed ledger allow for simultaneous access, validation, and record updating in an immutable manner across the network. As I reiterate, the facts of the case clearly states it is hosted across hundreds of digital nodes in many countries across the world, Your Lordship. This is clearly implies that this distributed ledger is a public blockchain, Your Lordship. Furthermore, the the aspect of terminating or excluding traders is merely an aspect of algorithmic trading. It has nothing to do with the nature of the distributed ledger technology logic. This algorithmic trading is even used in stock exchanges and etc. Therefore, to imply that only because this distributed ledger, that is Clevity, is using algorithmic trading, which excludes the members, it cannot be concluded that it is a private blockchain logic. Furthermore, as I stated earlier, um, the Article 5A1B, it's very expansive. I've never stated that the contract was fully finalized in the IFC logic. Even a partial performance or a partial conclusion would be sufficient to make the gateway. Your Lordships, this was held in the case of Al Khurafi versus Bank Sarasin, paragraph number 60, which clearly states even if there is a connecting factor between partially agreeing to a contract or partially performing a contract, that would be sufficient, Your Lordship. Moreover, in accordance with the consensus mechanism, what makes this distributed ledger a public ledger and hosts the consensus mechanism is that all the nodes in the network consent to a transaction. In that aspect, even including the node in DIFC lordship. Also, the undisputed fact, which is the Clevity operated the node in DIFC, would be irrelevant because why had they mentioned such a thing if they wouldn't pertain to such facts, Your Lordship? Furthermore, Your Lordships, um, also as I stated earlier, in the case of Ray Tezo's Civil Litigation Center, since the nodes were hosted on a server in Arizona in the US, it was sufficient to determine jurisdiction. I've stated not one but two specific case laws that support this. Your Lordships, if that may not be sufficient, I will now cite another case law which further reiterates my stance. Lordships, in the case of Mine Ukchoy versus Tau Research Capital, which was held in the US Court of Appeal for the Second Circuit in 2018, clearly states the location of the performance would pertain to where the matcher's bid and the buyer's bid is matched on a server. Therefore, Your Lordship, the fact that this node is on a server in DIFC would be sufficient. Um, Moreover, Your Lordship, as I clearly stated earlier, it is the exclusion of the people who has less than a cash margin is an aspect related to algorithmic trading. It has nothing to do with the distributed ledger, nor the nature of private or public distributed ledger technology lordship. If may please turn to page number 4 of the code bundle, Your Lordships. The first ground of appeal clearly states that it operated distributed ledger with the node in DIFC, and that is not a disputed fact. It is an undisputed fact, Your Lordship. It's not even a question of fact. Furthermore, Your Lordship, the appellants have failed to state which is a more appropriate forum. In the case of Protivity Member Firm Ltd versus Al Mohil 2016, the case was between the jurisdictions of UAE, DIFC, as well as Saudi Arabia. However, the IFC has seized jurisdiction over the matter based on the fact that it is more convenient, as the burden of proving that the case is more appropriate on another forum, it is on the appellants which they have failed to discharge, Your Lordships. Your Lordships, that concludes my side rebuttals. Much obliged.
Thank you, Counsel. Thank you. Junior Counsel to the appellant, you may now proceed. Counsel?
Oh, sorry. Could you not hear me?
Yes.
Yes.
Oh, sorry, my mistake. May I continue?
Yes, please. Thank you.
Thank you. Okay. good faith is not relevant to deterministic algorithms, as good faith relates to on-the-floor meetings and trades. By agreeing to use deterministic algorithms, the parties involved today have agreed to trade without reviewing the terms of the trade prior to it being carried out. The disputed trade was not made in bad faith, as I have already established that Mr. Payne did not program Beta maliciously to exploit mistakes. He instead merely added the inflated price as a way to ensure that the program would remain functional in the unlikely event of a server crash. The respondent has cited cases that deal with contracts made face-to-face and is requesting that the court set aside the factor that algorithms were used. This cannot be done as the main conflict arises from the fact that the trade was carried out while the parties were asleep. While this respondent cited Lord Mance's judgment, I would like to reiterate that this opinion was heavily criticized in the final judgment by Chief Justice Menon for being wholly artificial. As set out in Coin, the state of the mind of the programmer at the time of programming the algorithm must be considered. If it is not, then the trade would be avoidable. However, as Mr. Payne had not programmed Beta maliciously, he had indeed programmed the algorithm to make trades in good faith. That concludes my rebuttal. Thank you.
Thank you, counsel. Junior counsel to the respondent.
Your Lordships, as mentioned by the appellants, the dissenting opinion can be used as a fact, as a case states that the state of mind cannot be taken into consideration, as the objective theory is the best considered principle which talks about a reasonable trade. Moreover, the state of mind that was known, okay, as stated before, Article 56 of DIC contract law states the implied concept of good faith to be applied to all the contracts. Hence, the concept of good faith and reasonableness is implied to all the contracts. Moreover, the appellant has taken the opportunity of the circumstance of pricing the cryptocurrency at a highly inflated price. Moreover, paragraph number 10 of the facts clearly states that the state of mind cannot be used in this court, and hence the principle of objective theory can be reasonably used in this case. That's all, your ladyship.
Thank you, counsel. Thank you all. This concludes the submissions. I thought you presented very well. Your submissions were very well structured and presented. You were confident, and you all made effective use of legal principles and citations. So thank you so much. I believe Judge Rodrigo is online as well. So if you have any comments.
Yes, Samir, thank you. Yeah, I agree. I agree that that was an excellent presentation. You clearly have familiarity with the materials. You put the hard work. One maybe since it's an advocacy exercise, one remark you can make, and it applies to both sides, is to work on delivery of your speech. So sometimes less words are more effective than more words, delivered quickly or, without posing the right accent to the argument that you're making. So think maybe for the future, think about the things that you really want to focus on. It's not necessary to say everything to the court. It's necessary to say the things that really matter. Thank you.
Thank you, Judge. And I believe this concludes the session. Thank you all.
Thank you so much. Have a good.
Thank you so much, judges.
You too.